Good morning, everyone, and thank you for joining us. My name is Jason Cogdell. I'm one of the benefits attorneys for ProBenefits, and I appreciate you joining us for our monthly client webinar. As always, we try to provide benefits compliance topics of relevance, and what we thought, we actually made an adjustment to the schedule for this particular session, thinking that as we get halfway through the year, as most of the ACA requirements have gone into effect, with a couple of minor exceptions that I'll address today, we can start to see the smoke clearing, not from the ACA as a whole, but at least from some of the key employer requirements, that we might stop at this point, which unbelievably is almost the midpoint of 2016, which is flying by, and see where we are relative to some key benefits compliance issues looking ahead for the rest of the year. So in some ways, this is an update to the session we did in December, which was projecting key compliance issues for 2016, and clearly we know more now than we did 6 months ago. And in part, this is just kind of where we are now. So I hope that this session will not necessarily provide a lot of new information for you, and I certainly hope it won't provide a long action plan for you as much as confirming where you are as an organization or as an advisor advising employers of various sizes, and can help you plan out kind of what you're looking at from a compliance perspective for the rest of the year. As always, your questions are welcome via the question box. And before I launch into it, I want to say a quick word about our June webinar. We had the new idea for 2016 that we would have one webinar, which we're going to do the third Tuesday of June, and allow the attendees to choose the topic. So you'll see an email on this, but if you have any particular suggestions, you're welcome to email to myself or Chris McCauley. What we're going to do is basically invite everyone who's attended a webinar in 2016 to vote on what topic you'd like to see for our June webinar. So we're going to follow up with that, but I hope that'll be something of interest to you. We're trying to mix up these webinars between single topics, updates, some of our mini webinars, which have been really well attended, where we take a kind of a basic benefits topic and handle it in 15 minutes, and we've got some more of those coming up the rest of the year. So you can always see our webinar schedule at ProBenefits.com, and your feedback is always welcome. Appreciate the opportunity to work with each and every one of you. As we start to look at benefits compliance updates, this is not directly a benefits topic, but it is a topic that affects many employers, and that is the topic of the new Department of Labor overtime rules, which many of you have been following. Those rules have been anticipated for all of the year. They were actually released yesterday, so I thought I would take a minute for those of you that haven't had a chance to read about the new rules yet, and just give you a quick overview and summary of the rules, with the disclaimer that I am not an employment lawyer, and we at ProBenefits don't do employment and labor work. These rules affect us. They affect small and large employers, so I thought I would mention them. I think, while it's not a direct benefits compliance topic, it is a topic that will affect us all, and anything affecting employment, ultimately affects benefits as well. So I think it's worth the time to look at. These are new rules that were released under the Fair Labor Standards Act, FLSA. They changed the rules about who is an exempt employee and who may be eligible for overtime. These rules are going to go into effect December 1, which is good. I was under the impression that we were only going to have 60 or 90 days maximum to comply as employers, but we've got until December 1st. And the short summary of the change is this. It's more complicated than this, but this is the bottom line for us as employers, is that in general, as you know, employees that work more than 40 hours are eligible for overtime, time and a half pay for the time over 40 hours. But overtime is not required to be paid by the employer if the employee is exempt. And the primary exemption is for employees that are white-collar employees that handle administrative, executive type duties. To be a white-collar employee, you have to pass two tests. One is based on salary, and one is based on duties. There was no change to the analysis of what duties constitute a white-collar employee and what are administrative responsibilities, etc. But the big change is to the salary basis. The old rule was that the salary basis was $455 a week or $23,660 annually. So if an employee was on a salary basis making more than $23,660, then that employee was automatically exempt from overtime. So that person could work more than 40 hours. The employer didn't have to track hours. The employer didn't have to pay overtime. The new rule released yesterday and effective December 1 increases that salary basis, effectively doubles it to $913 a week or $47,476 annually. So now employees that are on salary making less than those amounts, $47,476 annually, could be subject to overtime if they work over 40 hours. So that leaves the employer several options. Number one, we can, as employers, can pay them more so they're not subject to overtime. Number two, we can manage them so that they don't work 40 hours, either by reducing their schedule, hiring other employees, etc. It may require some employers to track time that haven't been tracking time for these employees. There is a very good blog post that I read this morning that was written by the DOL's director of the Wage and Hour Division, and you can find it easily on DOL.gov. I think that would be helpful for those of you who are just getting up to speed on this new rule. But the good news is we've got 6 months to comply. The bad news is we've only got 6 months to comply and figure this out. So again, I share that as a key update because I think it's something that affects many of us, whether we're employers, advisors, small, large, for-profit, nonprofit. This rule is going to be a big deal. I think it doesn't have a direct impact on benefits, but it could have an indirect impact. For instance, if we as employers end up paying more to some employees to get them above the salary amount, well, that may affect what we're able to do for those or all employees excuse me, from a benefits perspective. So this is going to be one of the major HR topics for 2016, starting today and going through the rest of the year. So I want to mention this just so that we're all aware of it. And since I think it's important as we're talking about key compliance topics to acknowledge what is the biggest deal going on right now, even if it's not a specific benefits topic. So anyway, a lot of you work with employment counsel or HR consultants. Those would be certainly individuals to contact regarding further information on this. And again, I'd steer you to DOL.gov as a great place to get started. That's where I started my day today in making my preparations for changes that we'll have to make here at our company. As a second time-sensitive update, and actually even more time-sensitive than December 1st, and just as a quick refresher, those of you that represent organizations that have more than 50 employees and are applicable large employers under the Affordable Care Act know that this is the first round of reporting. Many of you have finished your reporting work already, either doing it on your own or with the help of a payroll company or other third party. Deadline number one for reporting was March the 31st. These were extended deadlines. Deadline number one was March 31st, when all applicable large employers had to distribute the employee statements, Form 1095-C, to the employees that were full-time during 2015. That was the initial deadline, and effectively it was an informal deadline because we needed to give the employees those statements, but we hadn't had to do anything yet relative to the IRS. Tuesday, May 31st, which is obviously a week and a half from now, is the key deadline, the primary deadline. That is when employers have to submit the IRS form 1094-C, one copy from each tax ID to the IRS, along with copies of all of the 1095-Cs that have been distributed to employees. So this is the key deadline. This is the deadline that if we miss it as employers, we start incurring potential fines from the IRS, $250 per form per day. So we need to hit this deadline. Electronic filers, those using the IRS's AIR system of submission, which include anybody who voluntarily did it through a third party or large employers that are submitting more than 250 forms, actually have another month until June 30th. But for most of us, May 31st is the deadline. So I mentioned that just as a refresher. I've talked to some employers who have said, we shared the employee forms by the March 31 deadline, but we've since realized that a lot of those forms were incorrect, that we didn't fill them out right, or we needed to supplement them. What should we do? Most employers that are in that situation are correcting those forms to send the updated version to the IRS so that the form submitted to the IRS is updated and correct. And then that would just leave you with the decision of, do you want to give the employee the updated copy as well, or just move forward? Certainly the best practice would be to give the employee the updated form as well, even though it really won't impact the employee either way. The only other quick item I'll mention is that for those of you that qualified for the 50 to 99 one-time exemption from player pay, so reporting applied for 2015 to any employer that had 50 or more full-time employees plus equivalents in 2014. We always look back to the prior year. So for 2015, look back to 2014. If the employer had 50 or more, they had to report. Some of you were in the 50 to 99 range where you did have to report for 2015, or you do have to report, present tense, but you were exempt from player pay and any potential mandate penalties for 2015. If you were employers, I hope you realize you have to claim that 1 year exemption on the 1094C that goes to the IRS. So if you haven't, you need to. If somehow you submitted the 1094C and didn't claim that transition relief, you need to amend it, because you don't get the 50 to 99 relief unless you actually claim it on the 1094C. So that's probably the most important thing about the 1094C for employers under 100. For employers over 100, then you weren't exempt from player pay in 2015, and the government, the IRS specifically, will use the forms to identify whether or not you complied with player pay and may be subject to potential mandate penalties. But you should have claimed the other transition relief applicable to large employers as well. So it's important that we do these forms and we do them right. And we're all in this boat together, and this is the first round of reporting. If anyone has not submitted the 1094C and you're in the process of doing that, especially if you're doing it yourself, we do have available a short YouTube training session on the 1094C. If it may be helpful to you, we'll be happy to share that. And the other thing is that this requirement is not going away. It wasn't a one-time requirement. In fact, the deadlines were extended this year, but the deadlines are intended going forward to be on the same schedule as the W-2, W-3 submissions. So the employer will have to give employee statements in January 2017 for the 2016 year, and then file them with the IRS by the end of February. So good news is we're almost done with this first round of reporting. The bad news is it's going to hit us again in 8 or 9 months. So we've got to turn around and do it again. So that's something we want to be cognizant about. But I wanted to mention this since the deadline is coming up. So those are 2 of the time-sensitive items. In terms of revisiting the list, I shared a list at a December webinar that Chris McCauley and I did as part of this webinar series. We looked at kind of the end of the year 2015 compliance issues and projected 2016, and I shared a list very similar to this about what I projected to be the key compliance requirements of 2016. So in terms of revisiting this list, and I'm not going to go through all the items, I think the number 1 and 2 items are the reporting and then revisiting player pay, and I'll mention more about that in just a moment. So my first suggestion for every employer, small or large, is to make sure you know where you stand with reporting. Do you have to do it? If so, have you done it? Have you completed everything? And then looking ahead and preparing for next year. Player pay, does it apply to you, employer? If so, when do you need to comply? What do you need to do? Other than those 2 items, and then again, the new overtime rules requirement, which is not technically a benefits topic, so that's why it's not on this list. Then I think the other key items of 2016 are some what I'll call back to the basics topics. Let's look back and see if there's anything we missed in the flurry of ACA activity the past several years, more than 2 certainly, now that we're 6 years into the ACA era. What about ERISA? Do we have SPDs for all of our ERISA plans that we can identify? If we were audited, which is unlikely to happen, but if it does happen, we need to know what are our summary plan descriptions, SPDs, for each of our benefit plans. Are we relying on the carrier booklet? Do we have a wrap SPD? Do we need a wrap SPD? That's something we're dealing a lot with employers right now. For those that have more than 100 participants in their plans, are you filing 5500s? Are you filing them for all your benefits? Let's get back to the basics on that topic. HIPAA continues to be a topic of increasing importance. I'm not going to go into detail on HIPAA today. We'll do that in another session, but I want to raise this because, as I mentioned in December, HIPAA continues to be a key topic. It's a topic of great potential liability for health plans, and so we need to make sure that we've addressed it. Let's be honest here, HIPAA is incredibly painful. like the ACA, none of us want to spend time in the nuts and bolts of HIPAA. It's painful, it's unpleasant, but no matter how painful it is, we need to make sure we address it. Now, for those of us that have fully insured health plans, HIPAA compliance is not that problematic. We've largely outsourced HIPAA compliance to the carrier. We're probably not handling PHI inside our organization or inside HR, but we still need to make sure that we've done what we need to do. As an example, if I'm a fully insured health plan sponsor, I need to make sure that I have a business associate agreement in place with any of my vendors that handle PHI. That would include not only my insurance broker, which I should have a business associate agreement in place with if they have access to the protected health information of the participants, but also any other individuals or vendors or people that are in our building or have access to our files from an electronic perspective, from a hard copy perspective, or a plan administration perspective. That would include, as an example, companies like us at ProBenefits who work with employers on health FSAs, HRAs, COBRA administration. If you have access to PHI, you want to have a business associate agreement in place, with the vendor. Also, you want to make sure there are privacy and security policies in place. The carrier may be taking care of that for you, but if not, you want to make sure you've got that on file as the employer in case you need to share that. Another topic for this year for employers that are sponsoring wellness programs, telemedicine benefits, or other non-core insurance services. Make sure you've addressed any compliance needs. As an example, telemedicine continues to be very popular as a new benefit. If you're sponsoring a telemedicine benefit, and if it's not integrated part of the major medical plan, then that telemedicine benefit is subject to ERISA, and you need an SPD, and it is likely subject to COBRA. So that's something that we want to address. And of course, there could be legislative developments and surprises, of which there really haven't been so far in 2016. And the last positive legislative developments regarding the ACA or benefits were all the way back in the fourth quarter of 2015. There certainly may be some surprises the rest of the year. The new DOL overtime rule, by the way, was not a surprise. We've known that was going to happen for probably 6 months, and that was an agency regulation matter where the agency just released the new rules. It wasn't a matter from Congress. Certainly my expectation as a benefits attorney assisting employers and advisors is that in this election year, and now that we're within a 6-month window for the November presidential and congressional elections, I don't anticipate anything will happen, but anything is possible. And frankly, I wasn't expecting some good changes that happened at the end of 2015. So anything is possible. We're certainly watching for legislative developments, but don't necessarily anticipate that anything will happen until 2017 from the standpoint of Congress. So that's the list of projected key compliance issues and some quick updates. I did want to refresh the employer mandate, since a lot of employers are having to comply with the employer mandate for the first time in 2016 as employers that were over 50 full-time employees plus equivalents in 2015. And then also employers that kind of put this on the shelf, that this was a topic we talked about 1-2 years ago, then reporting took over and life took over and other important things were going on, and now the employer is starting to get back to what's important, and certainly the employer mandate topic is very important. Just as a quick refresher, and I show this slide wherever I can just because this is an area of tremendous confusion continually for employers, and that is, when does player pay apply to me, and if so, what does that mean? Well, let's start with when does it apply, just so everybody's on the same page. There was, I mentioned, the 1 year under 100 exemption that applied only for 2015. So starting in 2016, and if you look at the middle section and the second bullet point under the middle heading there where the cursor's moving, the employer mandate applies in 2016 to any employer that had 50 or more full-time employees plus equivalents in 2015. That's a 12-month average. So the employer, to find out if it had 50 or more, would literally look at every individual month of 2015, how many full-time employees worked that month, how many part-timers, calculate how many equivalents the part-time employees represent. If that number on a 12-month average is 50 or higher, then the employer is subject to the employer mandate in 2016. If that number is 49.999 or lower, then the employer is exempt from player pay in 2016. The employer mandate applied to many employers on January 1st, but certain employers get an extension until their non-calendar renewal date in 2016 if they meet certain qualifications, and I won't get into that right now. But the employer mandate is taking effect throughout the year 2016, in some cases for the first time for employers that are over 50. Reporting is part of player pay, and the same 50 rule applies. I assume that most of you know where you stand relative to reporting since the deadline is now upon us. So I think you probably know where you stand relative to reporting. You need to just revisit, player pay. Does it apply and when? For those of you listening that are under 50, question, do we have to do the math for 2015 to confirm that we are under 50? I would certainly recommend it. If you're clearly under 50, I don't know that you need to do the math. But if you're in the vicinity of 50, such that you would feel better if you did the math and you had it documented that you're under 50, even though you don't have to proactively give that to the IRS, I think it would be a good idea to do that, have it documented, so that if you're scrutinized, several years from now by the IRS about whether or not you were an applicable large employer in 2016, you would have something to fall back on, and you wouldn't have to recreate that work at the time. But where we stand right now, last year in 2015, there were 3 groups. Under 50 was exempt from player pay and reporting. 50 to 99 had to report for 2015, what we're doing right now, but was exempt from player pay. And then the over 100 had to do reporting and player pay in 2015. In 2016, we're back to 2 groups. You're either subject to reporting and player pay as a group that had over 50 last year, or you're exempt from reporting and player pay in 2016 as a group that had under 50 in the prior year. I got one question submitted about small group self-funded. I'm speaking generally. There is a reporting requirement that applies for employers that are under 50 but sponsor a self-funded health plan, and that's because the carrier is not required to do the B series reporting. So I was speaking generally about the C series, but it is true, to answer your question, that a small employer under 50 that sponsors a self-funded major medical plan would have to do the reporting, assuming that the carrier or the TPA that you work with did not do it on your behalf. So I went through all that quickly, but I mentioned this just because the amount of confusion and frustration from employers on this topic remains significant. So I wanted to mention this refresher. Now, if player pay applies to you in 2016 as an employer that had more than 50 in 2015, then first is determine the effective date, and I mentioned that. The second is identify what do you need to do at the effective date. Speaking very generally as a quick summary, and by the way, we have a very good one-page summary of 2016 player pay. If that would be helpful to you, I'd be happy to share. The 2 key components of player pay remain. Number 1, eligibility. We have to ensure that we've offered coverage to all or substantially all 30-plus hour employees, regardless of job title, regardless of whether they've been benefit eligible in the past. For health insurance only, the ACA definition requires us to offer coverage to individuals that work 30 hours a week, and the monthly standard is 130 hours a month. So that controls for health insurance if we're subject to player pay. If we're not subject to player pay, if we're a small employer, we're not stuck with a 30-hour rule. The carrier may require it, but it's not legally required. But if we're subject to the mandate, the 30-hour rule, 130 hours a month, controls. So we need to make sure we offer coverage to everybody when the mandate applies to us to avoid the large A penalty, the A penalty, which is known as the sledgehammer penalty. The second component of player pay is affordability. We not only have to offer coverage to employees, but we have to make it affordable. Affordability is based on a 9.66% standard of which measures the employee-only premium, the employee share of the employee-only premium relative to the employee's income. And the IRS gives us 3 safe harbors to make sure the coverage is affordable. And if we meet those safe harbors, then even if the employee turns down the coverage and goes to spouse's plan, goes to Medicare, Medicaid, or even goes to the health insurance marketplace, then we, the employer, will not be penalized because we offer the employee affordable coverage. Whereas if we offer coverage to the employee, but it's unaffordable under the affordability standard, and the employee turns down our coverage and goes to the health insurance marketplace, then the employee would be eligible for a subsidy there, and that would cause a potential penalty. Notice the B penalty, or the tack hammer, which is a penalty, a one-by-one penalty only for the employees that get a subsidy after being offered unaffordable coverage. I am not, in the interest of time, going to go in any further detail on player pay, other than to say I want to raise these issues again because this is something we talked about a lot 1 to 2 years ago before reporting started dominating the airwaves. But I think it's something employers ought to revisit to make sure everyone who should be eligible is eligible, and also that affordability is addressed. One of the questions submitted, do we have to count independent contractors or 1099 employees? No. The employer could theoretically cover independent contractors in a plan if the carrier allows, but for affordability and for eligibility of coverage in the 30-hour rule, we're only talking about common law employees. The ACA defines an employer's responsibility relative to common law full-time employees, so we're only worried about W-2 employees. One of the sessions I'm considering for the next few months, and it may end up being the June session, is a guided quiz on basic mandate issues. I've been working as part of my training and seminar work. I've been administering a compliance quiz to employers on basic player pay issues. And what I'm finding is these issues are tough, and the questions are intended to be basic to moderate, not necessarily advanced. But I projected that half of the questions would be right, half the subjects would pass the test, and that projection has been roughly right on. Some people have done better, some people have done worse, but it has confirmed what many of us think, and that is that these issues are still confusing and frustrating, and we need to keep revisiting them to make sure that employers don't get in a situation of liability. So I'm not going to go through those questions today. If that's something you'd be interested in later as a webinar session, or for your organization or for your association or group, that's certainly something that we can discuss. In the final few minutes, I want to give you a couple of refreshers and then a word about best practices. By special request, I want to give you a refresher on the 2 applicable fees that are part of the ACA for 2016. The first is the PCOR fee, Patient-Centered Outcome Research, which is the one-time per year nuisance fee that applies to major medical plans and HRAs. It doesn't apply to health FSAs or other accepted benefit supplemental plans, but it does apply to major medical plans and HRAs. Some of you may say, well, what's the PCOR fee? If you don't know what it is, great. That means you probably just have a fully insured plan. The carrier's taking care of it. You haven't had to worry about it so far. Or, for instance, for the HRA plans that we administer at ProBenefits, we handle the PCOR fee submission, calculation, form preparation for the employer, so the employer doesn't have to do anything but just sign it. We feel like that's a nice value-added service for HRA administration. But the PCOR fee is due July 31st of this year for plans that ended in the 2015 calendar year. Specifically, plans that ended between January 1st of 2015 and September 31st of 2015 will pay a $2.08 per participant fee and submit that with IRS Form 720. Plans that ended in the fourth quarter, October 1st through December 31st of 2015, will pay a $2.17 per participant per year fee, again with IRS Form 720. Again, if you've got a fully insured health plan, the carrier is legally required to do it. If you've got a self-funded major medical plan or self-funded HRA, well, all HRAs are self-funded, then you, the employer, are responsible for the filing. So you can either do it yourself or get some assistance from the TPA, in this case ProBenefits, to prepare the 720. And if there's any further information you need on that, let us know. One of the questions, when will the PCOR fee go away? It's not intended to be indefinite. It was scheduled to apply for 7 total plan years. So most employers started filing the PCOR fee for the 2012, the plan years that ended in 2012, so they'll file them for the plan years that ended in 2012 through the plan years that end in 2019. But you're supposed to file the PCOR fee for 7 plan years. So some will actually go past 2019, but we're effectively right in the middle of the PCOR fee submission. So it's the dollars are small. You know, it's $2 per year per participant, but it is something we have to do and make sure we don't miss. So that's why I raise it. Again, if you only have a fully insured health plan, you don't have an HRA, you don't have a self-funded major medical plan, then you don't have to file the PCOR fee. Good news for you. But if you've got the self-funded major medical plan or HRA, that's something that needs to be filed. And if you missed it previously, you just need to make sure you start filing now and go forward, and hopefully that won't be an issue. A second fee is the reinsurance fee, and I can share some good news on the reinsurance fee. This is not a nuisance. Well, this is a nuisance fee, but it's much more than a nuisance amount. The amounts have been huge for the reinsurance fees, so significant that they've had a major impact on rates. The 2014 amount, which was the first year that the reinsurance fee applied, was $63 per year per participant, $5.25 per month per participant. That was a huge fee, had a major impact on rates. So for example, even if you have a fully insured plan, the carrier actually was required to file the reinsurance fee. Well, they just built that into the rates. And so that literally had a $5 per month per member impact on rates. And it had that impact again in 2015, although the amount went down. The good news is the amount is decreasing significantly for 2016 and then expiring. So unless there's a change from Congress, which I don't expect, this fee will expire after 2016 and we will not have to deal with it anymore. So the 2016 amount is due beginning November 15th. That's when we submit the participant count to CMS, and this is the fee. Some of you will recall that self-funded employers are using pay.gov. So fully insured carriers are filing it for the plan. Self-funded plans are doing it themselves through pay.gov unless the TPA is doing it, which some are. And HRAs, health FSAs, other plans are exempt. So good news there. So the amount for 2016 is relatively small compared to the prior years. It's $27 for the entire year, $2.25 per member per month. So the amount has dropped, and then next year it goes to zero. So let's keep our fingers crossed this thing doesn't get extended and we move on. So just wanted to say a brief word about that, since this has had an impact on rates. And I'm not suggesting that when this fee expires this year, rates will go down for insured plans in 2017, but I think it will help stabilize rates, the fact that this fee will not have to be paid anymore, and it's something that the carriers and the employers will not have to worry about. So that's just a very, very quick overview of the reinsurance fee topic. As a quick word about best practices, as you're looking at the rest of the year, we mentioned the DOL overtime rules. That's on our list as an HR and benefits representative. Let's confirm that we are where we need to be on ACA reporting and player pay. Let's put HIPAA on our list, no matter how painful it is. And let's also consider getting back to the basics on some general topics. For instance, I mentioned ERISA. Do we have an SPD for our plans? What about our Section 125 plan? Hopefully that's something we're administering for your organization, whether you have a pre-tax premium plan or a plan that has flexible spending accounts as part of the 125 plan. But if not, do you have a document? Can you locate it? Is it up to date? Does it include all the things you're pre-taxing now? Does it include an updated definition of legal spouse? Does it include the new IRS qualifying events? That's something we can help you with. Let's get back to the basics and make sure that in all of the chaos of the ACA era and reporting and player pay and other things, let's make sure we haven't missed some of the key basics, which we want to make sure to cover. And if you want more information on that, I'll be happy to discuss with you. And then also I would put on your list, to schedule sometime, not necessarily this month, but sometime over the next 12 months, a benefits compliance checkup, which is something you can do yourselves. I typically advise employers this. I was asked recently on a compliance panel, if you could do one thing, wave a magic wand, and every employer would do one thing, what would it be? And this is what it would be. I would suggest that the employer take one piece of paper, electronically or in hard copy, and draw 3 columns. In column 1, list every benefit that your organization sponsors, starting with 401k and major medical. Obviously, we won't miss those, but going all the way down to the minor things. Gift card programs, snacks in the break room, something, any employee benefit we provide, no matter how large or small, we put it in column 1 so that we identify what are we doing in HR and benefits, what are we dealing with. Column 2 would be taxes. Are we handling the taxes correctly? Obviously we are for 401k and group health insurance, but are we for disability? There are options there to protect the tax-free nature of future benefits. Are we handling group term life correctly? For example, employees can pre-tax up to $50,000 in group term life insurance coverage, but not more than $50,000. So are we doing that correctly? Snacks in the break room. Thankfully, in my case, Diet Dr. Pepper is not taxed for my employer. It's a de minimis fringe benefit. We're not taxed on that. But gift cards, in theory, we should be taxed on gift cards because that's not a de minimis fringe benefit. Now, do employers tax employees on gift cards that they provide for achievement or acknowledgement or incentives? Generally, employers don't. I did have, by the way, someone raise a hand at a recent session and say, we do. So at least one employer in America is taxing employees on gift cards. But we just want to know what the rule is. You don't have to know the answers, but you need to identify what the questions may be. So column 2, are we handling these benefits correctly from a tax perspective? And then column 3, compliance. What compliance rules apply to these benefits? Well, snacks in the break room, it's not a benefits plan. It's not a policy. We don't need a summary plan description. We don't need to worry about ERISA and HIPAA and COBRA. But these other benefits we do, I mentioned telemedicine, wellness programs, disability. Let's make sure we have an SPD. Let's make sure we've assessed whether that benefit is subject to COBRA, whether we may need to file Form 5500s or not. How does HIPAA apply to these benefits? So I'm going to call column 3 generically compliance. What compliance rules apply to these plans? You in HR benefits don't need to know all the answers, but you need to have the right insurance advisor, agency on your team, the right compliance partners to help you figure out. My experience in helping employers with these types of compliance checkups is that most of the time the employer is doing nearly everything right, but there will be some matters to tweak and improve or adjust and get everything in order. So that's certainly what I would recommend. So thanks for being with me and talking about best practices, and I know we went a few minutes over. In light of that, I am not going to answer any more questions right now. I will hang on for a few minutes and answer some of the questions in writing if that would be helpful to you. So if you want to hang around to get your question answered in writing through the question box, see answers to some other questions, or submit some new questions, feel free to hang around in the next few minutes and I'll answer questions for 5 or 10 minutes. So thanks for joining us today. Be on the lookout for a follow-up email with a copy of the slides and a link to the recording, and then also some more information about our June webinar when you will get to choose the topic, and your feedback is welcome. You can propose anything and we'll certainly consider it and put it up for a vote and allow all the individuals that have participated in our webinars in 2016 to make a good choice. So on behalf of myself and our team at ProBenefits, thanks for attending. Best wishes for a great afternoon and rest of the week.